All right, guys, this is Alex with a live stream on the topic of judges interviewing children. I am here with an attorney from Utah. His name is Eric Johnson. Go ahead and introduce yourself to the viewers. You can also go ahead and talk about your channel a little bit, and then we'll go ahead and get into the topic.
I'm Eric Johnson. I've been an attorney for about 24 years. I practice in Salt Lake City, Utah. But the reason that we are talking today is because of some other things that I do, not just as an attorney representing parties, but some of the things that I do on my own as they impact the profession and the impact they have on people in the family law system. So I created Utah Family Law TV, a YouTube channel, I think around 6 years ago, if I remember correctly, when I read about a rule that they had recently passed in Utah that said, in the interest of making the public proceedings of the courts more open to the public and more accessible, they made it easier for the news media to cover these proceedings. Well, I was not a member of the news media at the time, but I thought this would be a wonderful thing. When I realized that they wanted more people to be aware of what happens in the courts, I said, well, most people, if they ever do have any kind of contact with the court system in their lifetimes, it might be a big percentage of them might be through the divorce or child custody proceedings. So I said, this is something a lot of people don't know anything about when they come to me as an attorney and hire me. They're scared, they're anxious, they don't know what to do, they're ignorant of how the process works. They're surprised, often shocked by the law and how it's applied. And I thought, wouldn't it be wonderful if people could watch actual proceedings and then they could learn, well, here's what the law is, here's how the law gets applied, whether it gets applied correctly or not. Here are the ways people get treated, that sort of thing. You could even get to see particular judges depending upon what county you're in. So that's what I've been doing with Utah Family Law TV. But Utah Family Law TV also produces content on the subject of family law, answering questions that people have. Obviously, they are focused on Utah, and every now and then I will comment on things that may apply to other jurisdictions, but of course you'd have to make sure that you check with an attorney in that jurisdiction. Otherwise, just kind of take it as something that's informative, maybe pointing you in the right direction. But clearly, Utah law isn't the same as law anywhere else, although there are a lot of similarities.
That was a fabulous introduction. We've already got some pretty positive comments from the viewers. Guys, as with all of my live streams, remember this is driven by your questions primarily. We try to definitely engage with you, otherwise we would just publish a standard video. Couple of comments from HC9 saying that he's watched a bunch of your videos yesterday and he's very excited to hear from you. Comment from Shay saying Mr. Johnson seems to be blazing a better trail for family court. Great video of his titled, quote, The Darkness, unquote, with Gary Klein. Another comment from Florence Thompson. Hello, glad to be here for this. And we have several other comments. If you guys see me looking over to the side, I have 3 monitors set up. When I look over to the side, I'm looking at your comments, and I'm going to be fielding your questions to Mr. Johnson. If you ask me questions, I'm going to save those for the very end of the live stream. We're primarily here for Mr. Johnson and his topic today. So you said so many things that I didn't even know. I did not even know that in Utah they were opening up access to the courts electronically, electronic proceeding coverage. That's actually very consistent with what I do in Nevada for our Nevada judges. Now, I still face obstacles to family court coverage. It sounds like your situation may be different. We can set this aside for another day, this topic in particular. But one of the great things about having you on is I get questions all the time about the use of custody evaluators, the use of parenting coordinators, the use of third-party experts in child custody cases. And even though I represented myself for 8 years, I didn't actually use any of these at any point in time. So this leaves me with a huge blind spot on my channel that I noticed immediately. You could be very helpful to my viewers. So why don't you go ahead and go into the main topic today before we go into questions on why your position is favored towards the judge interviewing the children instead of these third-party experts, custody evaluators, and coordinators. Go ahead.
Well, first of all, let's talk a little bit about what a custody evaluation is, okay? And it may have a different term in different jurisdictions, but it's probably something that you would be able to figure out just by its name. What were some of the terms that you had used?
So we have parenting coordinators, which have within the last
Okay.
year or two have been severely curtailed. The Supreme Court of Nevada piped in on those. We have custody evaluators, which still are in full swing here, especially in District 8, which is Clark County, Las Vegas. It's our largest district. And then we also sometimes the courts will involve third-party expert witnesses. Typically, it's some kind of expert on marriage and family therapy or a child psychology or something like that. So the
And
courts
then I
use
would
all of
add to
those.
your, yeah, and I would add to the list guardians ad litem, right? And you
Right.
have those. And so let's talk for, I'll briefly describe for people that are maybe encountering, their child custody dispute from the beginning, and this may not even come up yet, but let's let people know what that is. So parent coordinators oftentimes are sort of like someone who's placed in charge of the couple and their family so that the judge or the court doesn't have as much time taken up and as much effort or burdening them so that because judges do have, in most cases, far too many cases than they can handle effectively. And so if they can ever lighten the load, that's a good idea, as long as they're not doing it at the expense of the welfare of the children or uh, the administration of justice. So a parent coordinator, like a lot of things, sounds like a good idea, but in my opinion has not really worked very well. The idea would be that you would go to the parent coordinator with your complaints or with your concerns, and then the parent coordinator would try to provide a solution or an idea to help the parties to resolve the dispute without it having to go to court. The problem is that oftentimes the parent coordinators really aren't that engaged. I'm surprised at the number of parent coordinators who come up with really lousy ideas. And on top of that, if you don't like what the parent coordinator did, you can always appeal it to your judge anyway, saying, I don't like what the parent coordinator did. So really all you're doing is just putting off taking it up with the court in many cases. They're expensive as well. They're not something that's free as opposed to the use of the judge.
Right. And before we go into the next explanation as to the next thing, I did have a few remarks on what you stated. In my suspicion was very much consistent with yours. I felt that in a high conflict child custody case, it was just going to be an extra step, and it was just going to be more money. They also usually have the parties sign agreements that make it easier to get attorney fee awards when their decisions are disputed, which makes me immediately suspect that that's going to be another problem. In Nevada, the Supreme Court actually published a case, I think it was within the last year, that stated that parties can actually veto the parenting coordinator now. If a party says they don't want a coordinator, the judge can't order it. If they do, it's overturned on appeal, just straight out of the gate. And there are a few other things that the Supreme Court of Nevada was concerned with. I guess they found it to be a constitutional issue with litigants' right to access to the courts.
Right,
But the other
delegation and the delegation of court power to a non-judicial officer, probably.
Right, and some of the feedback that I've gotten from people is consistent with what you say, which is that the parenting coordinator isn't really that interested in the case anyway, and so they're really not getting a thorough evaluation anyway. So I guess I like this format. Why don't we just go from one category to the next?
Okay.
Which one do you want? We're getting a bunch of comments. I won't bring these up yet. I'm gonna read through
Okay.
these, and as you
Yeah.
explain custody
Yeah,
evaluators, I'll
hold
go
those
ahead.
thoughts, folks. We're going to get these terms first, and then we'll address them all. So
Yeah.
the next one you have would be a guardian ad litem, and we're going to hold custody evaluator for last. A guardian ad litem, in Utah at least, and my guess is it's similar in your jurisdiction and in most other jurisdictions, is an attorney. So a guardian ad litem is oftentimes appointed for children in the interest of the children to address the rights of the children and to preserve the interest of the children. And again, sounds like a great idea. I've found it is not. I recently was in a forum on social media with a bunch of lawyers here in Utah about guardians ad litem, and everybody's like, oh, they do such a great job, they're so wonderful. And I said, well, then you've had an experience I have not. I can't say that I've always had nothing but bad experiences with guardians ad litem, but I've never had an experience with a guardian ad litem assigned to a case where I was just saying, oh, thank goodness that we had a guardian ad litem assigned to the case. Again, guardians ad litem tend to be not that much engaged. They do get paid for their work, so it's just one more expense that the parents have to bear, either together or sometimes they'll make just one of the parents do that. So you've got your lawyer if you have one. Not everybody does, but if you did, you'd have your lawyer. Then you have to pay for your half or all of the guardian ad litem on top of that. And then the guardian ad litem comes into court and does a lot of strange things that whenever I bring them up, nobody in the court system seems to have a response. For example, they'll say, well, I can't tell you what my client told me. That would be violating the attorney-client privilege, but here I go anyway. And then they'll say things like trying to kind of wink and get around it by saying, well, I can't tell you what my client said, but I will say that my client has the desire to do this or wants that, or is concerned about this. And I'm just kind of like going, okay, well, that seems to me like you're really just speaking for the child when the child has his or her own voice. And secondly, now I get to cross-examine this witness because you just came in and told me all these things and told the court these things. So I'm not sure I believe what you're saying. I did have one experience where the guardian ad litem says, I've spoken to the child and she said blah, blah, blah. And I happen to know that wasn't true. And I said, Your Honor, the guardian could not have spoken to the child and therefore could not have said any of these things. And the court was like, oh, thank you, Mr. Johnson.
Oh, man, that's alarming.
Yeah, it was just like, really? And then, yeah, and then the guardian kept talking. It was just kind of like, okay, whatever. So that's guardians ad litem. So the idea is they're supposed to speak up for the child when nobody else is looking out for them. If the parents are so wrapped up in themselves that they're giving the children's interests short shrift, the guardian ad litem is supposed to be there to stand up for the kids. The court system will praise guardians ad litem to high heaven. I don't know why. They're just not that. Okay.
Yeah, especially when they're being paid. So my remarks on that is some of my viewers from Florida and other states have stated that guardians ad litem are used routinely. I have viewers from other states, including Nevada, where they're not used very often, especially in districts that are not District 8. District 8 does, I hear some judicial departments use them routinely, others don't, but I litigated my case in District 2 and I never even heard of them, which is nice. We do have a special type of guardian ad litem that works with CASA, the Court Appointed Special Advocacy Program. Those are volunteers, but those are not used in divorce and child custody cases here.
Right. And
those
that's
are
a different
only
matter. Yeah. So sometimes you might have a situation where you're getting a protective order or an order of protection for a child who's alleged to be abused or neglected. And so in those situations, also they will appoint a guardian ad litem to represent and protect the interest of the child.
And it's just different because it's a different type of case.
I get it that, especially if the parents are at odds, if they're antagonistic or they're accused of harming a child, then saying, well, we don't need to have the child lawyer up. That may not make a lot of sense. So I can understand why there might be an attorney appointed to represent an abused or allegedly abused child. I'm talking about guardians ad litem, though, in the child custody space, where no one's accusing anybody of abusing a child, just saying, well, we need to find out what's best for the child by appointing the child an attorney, and that's why we're going to get to in just a moment. It's like, so the attorney will speak for the child. Now, the child is 3 years old, and can't really have a coherent conversation with anybody, and doesn't really know the difference between right and wrong, and doesn't understand what kind of issues are at play here and what kind of facts the court needs to establish. Okay, we can have that conversation later. But if you're a child who's 10 or older, you have your own voice. All right, we'll talk about that a little later.
Yeah, so let's...
Go
ahead.
Then there's custody evaluators. Custody evaluators in Utah, which I would assume are very similar to other places, are people who are psychologists or marriage and family therapists or licensed clinical social workers, or people of those qualifications are brought in, and then they interview the children, they interview the parents, they interview the children and parents together. Sometimes they'll watch them interact while they'll play a game of checkers or hi-ho-cherry-o, or sometimes they'll watch them as they will do something like that, and then maybe watch some TV together. Sometimes they'll make a home visit to each parent's home when the children are present to see how they interact. They will also conduct, if the court orders them to, they will conduct psychological testing and things like that to find out if there's something that's off with a parent or with the children and things of that nature. And then at the end, they will make a recommendation to the court saying, well, I was asked what I think would be the best custody award, and based upon my investigation and all the work that I've done, this is what I say. Now, I was very fortunate before you called me that just about a month ago, I met with a custody evaluator who had been out of the game for a while. And then some things happened, where there's just some life changes and stuff like that. So this was somebody in a different jurisdiction who moved to Utah, and this person could be more frank with me because there was nothing that could harm this person in the old jurisdiction. And I said, and I came right out and told this person, I said, I've never found the custody evaluator's recommendations to be all that clear and all that helpful, all that incisive or anything like that. And we pay, between $3,000 to $10,000 for your services, and then we get some kind of milquetoast response. And the evaluator said, well, that's because we're afraid of being sued for malpractice by the disgruntled parent or parents. And we're also afraid of being reported to the licensing bureau of our jurisdictions for being incompetent, whether we are or not. So we have to make sure that we don't step on any toes. And I said, well, that's ridiculous. I mean, then the service that you've been retained for, you're not really giving. And I understand you're doing it for self-preservation purposes, but still, you got to have the guts to do your job, or you should just turn it down. And this evaluator's like, yeah, I hear you. And that's what happened.
You know, I actually heard, we actually broadcasted some candidate interviews at an office from an expert who does custody evaluations. And I'm not sure if it was this custody evaluator or a different one, so I hope I don't get quoted on this. But I actually heard that statement, a similar statement from an evaluator, which was, you know, I've been practicing in this field and I didn't get a single complaint in all these years. And then I started testifying in court as a custody evaluator. Next thing I know, I have 4 complaints within 1 year. And it's exactly, everything that you said resonates very strongly with the feedback that I get from custody evaluators here. And of course, what you state with regards to the evaluations, I don't even understand why they make recommendations at all. I mean, I would have assumed that they were fact finders and they would testify as to what the facts were. And I always wondered, how can they recommend custody if they don't understand, you know, the legislative intent behind the statutes?
Testify to facts, what facts they can find.
Right.
It's a lot of this is really still going to be a lot of opinions. It's like, well, I can tell you as a matter of fact that somebody told me he or she feels this way. But yeah, but recommendations, I don't actually have a problem with the concept of an evaluator making a recommendation. I mean, for people that are new to the legal system, expert witnesses are that they are used for that purpose most of all. It's the opinion of the expert that we get. We usually don't bring in an expert witness to tell us facts, because facts can be ascertained without an expert. We know that the car hit that guy walking through the intersection, and whether the light was green or red, we don't know. But then when they say things like, well, did the impact of the car on the pedestrian cause the problems this person is suing for, or was this a pre-existing condition or something? You know what I mean? So opinions are important. But I do agree with you. It's nice when we can have opinions to a minimum and just say, well, we have facts that point us in the direction that the decision on child custody should go.
Yeah,
the problem I have with the opinions, though, as you pointed out and as I pointed out previously, is that they're asked to do a job they're too scared to do. My heart goes out to them. I understand. It's perfectly understandable for someone to say, look, I've been practicing for 10 years. Everybody said I was doing a great job helping kids, helping families. Then I got into the custody evaluation game, and I did the same job the same way I always have, and I feel I did a good job. I was taking it seriously, but then I got complaint after complaint. I got reported to, in Utah, it's called DOPL, the Department of Occupational Licensing. I got reported to DOPL. Somebody filed a lawsuit against me, all this kind of stuff. They even get threatened, it's kind of like, well, that's a nice practice you got there. It's a shame if something bad would happen to it. And so a lot of these guys get guys and gals, they get the idea. It's like, well, I better just say, well, the parents love the kids love the parents. Yeah, I do see a little bit of a problem here with mom and a little bit of a problem with that. But overall, and then what they often do, and this is my opinion, is because, and I understand, I'm not trying to attract controversy. I'm just trying to be as candid as I can. Some people will say, well, there was the doctrine of tender years that children are better off with mothers than fathers. Well, that's been abrogated largely in most of the states, but it's been replaced and gone underground with a thing called the primary caregiver. And so what will happen is they'll often default to, oh, by the way, primary caregiver is defined as somebody who provides the most personal care for somebody. So if you're a primary breadwinner, let's call him a father, and you spend 8 to 9 hours a day at work, you're not doing that so you can avoid your wife and kids. But when it comes to child custody, it will be held against you. And then when you say, if you were to have the nerve to say, well, should I have just quit my job before I got divorced so that I could have been an equal custodial parent? Like, well, no, that would have been irresponsible. It's like, well, it sounds to me like I'm being punished for being a responsible parent. I used to be a joint custodian. I'd come home every night to my children, and yes, maybe I was gone during the day, but that was so I could put the roof over their heads and food in their stomachs, and then I'm home and I do read a story and I do give a bath and and stuff like that. So custody evaluations, they sound great, but they are not even close to justifying their costs.
I couldn't agree with you more. I had a few comments on some of the precedent that you discussed in Nevada. We also had tender years. It was partially abrogated by Mosley v. Figliuzzi in 1997, and then in Rivero v. Rivero 2009, they totally squashed it. The legislature responded by codifying the precedent, and now at this point in time, they overturn decisions left and right when the joint physical custody preference isn't established correctly. One of the other big cases that came out recently in Nevada contemplates modifying custody when a person goes to work, just like you described, and the Supreme Court of Nevada specifically stated that a parent cannot lose custody in Nevada if they leave their children with a third-party caregiver when they go to work. The justices here are absolutely fantastic. They are on the ball, and they are, like I said, they're on a warpath overturning decisions. In 2020, 2019 alone, more than half of the appeals that went to the from family division to the Supreme Court overturned, which is huge. So we're getting.
No, and may I just say something really quick on
Go
that?
ahead, Josh.
I wish that we would see something like that elsewhere in the country, and I'm sure we are, but I'm sure there's other states where they don't. Where what they'll do is, I said, it goes underground, and what they'll
there's
do is
tons
they'll
of
say
them.
things like, they'll say things like, well, it's not that you're an unfit parent, primary breadwinner, but it's just we've got to confront the fact that the children are comfortable and spend a lot of the time with this one parent, and moving to 50-50. It's like, look, it doesn't come at a cost to anybody. It doesn't mean that the parent who was providing most of the primary care is somehow being punished. It just means that, hey, if you're expecting me to leave the house and to provide for the family, which I did, willingly and lovingly, but now I'm being told, no, you still have to shell out all the money for support and alimony, but you don't get to spend time with the kids. Now let's talk about something else that I'm sure a lot of your viewers are familiar with. If you've got a husband and wife, or a mother and father, who separate, and they now live 50 miles apart, joint physical custody is not going to work. It's just too much travel. It's going to be too hard to get kids to school and things on time, stuff like that. But if you've moved across town, if you've moved around the corner, stuff like that, and then they say, well, no, it's just not going to work. Like, well, then what will?
It's like they don't want it to work. They just don't want it to. What you're saying, again, completely agree with. I didn't want to make it seem like most states were like that. In fact, I feel like we're in the rare few. From what I hear from my viewers, most states are exactly the way that you described. And I have a saying that I say over and over again, which is, when the judges don't want to do something, they will typically use the windows of discretion that have been given to them. And so we'll still see the sort of tender use type of, in my opinion, abuse of discretion in Nevada, but it'll be in areas where the law allows it. So because the legislature,
or they will use a different excuse.
Right.
They'll give effect to the tender years presumption, but they'll call it something else.
Right.
Or they'll brand it something differently, or they'll claim it's some other factor.
Right. And it happens here. I have a video that I talk about the problem, and that's the video is titled Discretion. So hey guys, we're gonna go through your comments very soon. One more thing for Mr. Johnston is to elaborate more on the the judge interviewing the child. What mechanisms do you think are the best? If you even want, you can compare them, because I guess they've got in-chambers interviews. We have some rules in Nevada that were enacted within the last 2 years that don't really allow children to be interviewed in the courtroom anymore. Go ahead and just go all out and go into, and by the way guys, he has a series on this as well. So he has a series that he started and will continue on this exact perspective that he has, and go ahead and take over.
All right, so interestingly enough, I've always wanted to know this, but I stumbled upon it finally when I was doing some of my own research. And up until about 1965, if I remember correctly, if a child was 10 years of age or older and was found to be of sound mind, in Utah, the law was back then that the child had an absolute right to choose which parent he or she would live with when the parents divorced. Now, what's interesting about that is there was a presumption that the child could not live with both parents back then. I think that's kind of interesting. But let's set that aside for a moment. So if you were 10 or older, you got to choose. And of course, that meant the court had to speak with you. The court had to ask you, hey, 10-year-old, 11-year-old child, 16-year-old child, however old you are, your parents are getting divorced, and I need to know which parent you'd prefer to live with, because I'm not going to let you live with both. And so you've got to pick which one you're going to live with. Now, people seem to have picked up on the fact that this was traumatic to children. I'm sure it was traumatic to some children. And I do hear stories, I'm not sure they're true, but stories about how the child was told, get in the car, we're heading downtown, and they didn't know what they were doing, and then they were driven to the courthouse, walked in the door of the courthouse, and were told, Mom and Dad are getting a divorce, tell the judge who you want to live with. Now, if Mom and Dad handled it that way, and the court let them handle that way, then shame on Mom and Dad.
Mm-hmm.
My guess is what really happened is that the parents, being loving parents, even though they may not have wanted to stay married anymore, went to the children and said, Mom and I, your dad and I are getting a divorce, and you're going to have to spend most of your time living with one or the other. Mom and I cannot reach an agreement. I'm sure there's a lot of families that already decided what it was going to be, and it was the dads realizing that I'm a second-tier parent, so go ahead and live with Mom, because I don't want to put you through having to agonize. I get that. But if they did actually fight, or let's assume that Dad was saying, Mom's a horrible parent, Mom's a drunk, or something like that, then they would say, well, you've got to choose, because Mom and I can't reach an agreement. Well, then they would go talk to the judge. Now, what's traumatic about that? Talking to the judge? Of course not. That's not the traumatic thing. The traumatic thing is having to be put in the middle of a situation where you've got to choose, and divide your loyalty between your parents, where you've actually got to cut it off. So the first thing people will do is they'll say, well, children talking to judges, that hurts kids. No, it doesn't hurt kids inherently. I mean, yes, you could watch the interview if you're a bad judge, but just merely talking to a child about child custody isn't inherently traumatic. Now, how do we know that? We know that because the judges and the court system generally just embrace guardians ad litem and custody evaluators and all this other kind of stuff. Now, what does a custody evaluator do, or a guardian ad litem, that a judge does not when it comes to talking to a child about custody? The answer is absolutely nothing. The same questions would be asked, the same subject matter arises. It's just that one of them is being conducted by a judge, and another would be conducted by a lawyer, a guardian ad litem, and or by a custody evaluator, a psychologist, or a marriage and family therapist, or social worker. Now, let's be honest. Between a judge and a psychologist, I think we could all agree that a psychologist has a slight edge over the ability to interview a child effectively. But once again, you have to pay through the nose to have the psychologist do that, and I'm not sure that the difference in the quality of the interview justifies the expense. Secondly, if a judge feels I don't have the skills that help me to be a good child interviewer, given the fact that most of my work involves being in Utah, we don't have someone who's just a criminal judge, just a civil action judge. So judges in Utah hear all of these, which I think is good. Cross-training for the mind keeps you sharp, keeps you resourceful. But look, you're going to hear a lot of divorce cases during your career, Your Honor. If you don't feel you're good at interviewing kids, then get good at it, as opposed to just begging off saying I can't do it.
I love the cost advantage that you mentioned, and one of the things that you said that really resonates is that what really hurts the child is being put in the middle. And when it comes to high conflict child custody cases, the child's already in the middle. The parent the parent's going to put the child in the middle anyway. So there's nothing that you can do to get around that. I guess before I go into the questions, the one curiosity that I have is recently I mentioned that in Nevada we added to the rules of civil procedure how children can be interviewed, and I was interesting to see that one of the rules says that the interview must be recorded so that the Court of Appeals or the Supreme Court can consider the testimony of the child to see if substantial evidence supports the decision of the court. I'm curious if Utah has that same requirement.
Could you repeat that?
Yeah, the interview in chambers with the judge and the child, according to our rules of civil procedure, has to be recorded. And apparently the reason why, according to the Supreme Court, is that they understand that children can be put in the middle, but the issue is a constitutional right to actually have that decision reviewed, and they can't review it if they don't have a transcript. Now, I've heard that...
One thing, let me interrupt you there, I apologize. When you have a guardian ad litem appointed to speak on behalf of the child, the interview between the guardian and the child is not made part of the record. So you have no idea if the interview even took place. And as I told you before, that one guardian actually lied through her teeth and said, I've spoken to the child when she hadn't. Custody evaluators, same thing. The interviews between the evaluator and the parent and the evaluator and the children don't have to be recorded. They're not made part of the record. So once again, if you ever had a custody evaluator with some kind of agenda I don't like men. I don't like women.
Mm-hmm.
I don't like particular members of a religious organization, or
Mm-hmm.
I don't like black people. Whatever the thing is, that person could then say, I've made my interviews, I conducted my investigation, and then lie through their teeth, and there's no way for us to know what was said. We don't know how well the questions were asked. We don't know if the child responded. We don't know the child's tone of voice. But yet, with a judge, it's on the record.
Right.
So
In Nevada, it's required. They have overturned decisions straight. They won't even consider harmless error. They'll just throw it out. So let's go. We can talk about so many things, but let's stay on topic, or we'll go all over the place. So I'm going to go through the comments now. I'm going to look for specific ones. Looks like a question from Shay is, how did Mr. Johnson get into the cluster B side of divorce? Go ahead and take that one.
that is a question based upon the Gary Klein interview that you mentioned
Ah.
a little earlier. Gary Klein is a really a good guy, and when it comes to personality disorders, specifically the borderline personality disorder, we did 3 or 4 videos on the subject. Now, these are old videos, and so I apologize for the sound quality of them, but the content is still just pure gold.
Mm-hmm.
So I do not claim to be an expert on borderline personality disorders or personality disorders generally, and I will tell people this, because I know that if there are 100 people watching right now, at least 80 of them have this question on their minds: how can I use my spouse's or my significant other's personality disorder against them, even if that's virtuously, because I have a serious concern, so that I win custody? The answer is you can't. Nobody believes in this stuff in the court systems. They don't give it a whole lot of credence.
Mm-hmm.
It's very hard to prove. Everybody is going to be written off as, well, you're just mad because your relationship's breaking up, so you'll say anything about your spouse or your significant other.
Mm-hmm.
So I'll just leave it there with that.
Before I go to the next
Still
question.
good to know. Let me tell you this: it's still good to know if you're in a relationship with someone with a personality disorder, because it's
Mm-hmm.
ruining your life whether you know it or not. And there's a lot of people that are being subtly brainwashed and just being reduced to shells of their former selves. And
Mm-hmm.
so it's good to find out if you can break free of the hold they have on you. But as far as getting any kind of legal advantage over that, I've personally experienced that, where we knew that one of this spouse had serious personality problems.
Mm-hmm.
We were shocked to find out in the custody evaluation that the custody evaluator was unwilling to stick the neck out to
Yeah.
back us up.
Yeah, your advice is consistent with mine. I talk about that in the video evaluating mental health. Completely 100% on board with that. You mentioned views. You already have over 100 views, and you have 30 simultaneous eyeballs on you. And let's go into the next question here. I'm just going to scroll down. Let's see. We have most of these are to some of these are to me, not most. This was a curious question. I guess this is relevant. This is from Karen McNaughton. She is wondering how to get courtrooms open to electronic coverage in other states. I don't know to what extent you want to take that one, but go ahead and remark on that one as I scroll down.
Yeah, briefly, once again, briefly, I would look to the states that already have these rules in place, and then I would go to I would go to my legislators, or I would go to the committees that make the rules that govern court. Some states that may be done through the legislature, other states will actually leave that to the profession itself. Sometimes it's done by the bar, sometimes it's done by the Supreme Court. That's how it's done here in Utah. There's a rules committee that's overseen by the Utah Supreme Court. And so you could just say, hey, we should have, these are public courts, these are taxpayer funded courts, and they've always been open to the public, because that's the best way to ensure that the courts are doing their job and that they're not corrupt, that they're not being incompetent, is that letting people that are members of the public come in and oversee and watch what's going on, and then complain and take action to clean up the mess if there is one.
I couldn't agree with you more.
Yeah, I'd look around, I'd find out what laws already and rules already exist, and find out the ones that seem to make the most sense to you, find out the ones that maybe sound good in theory, but then you'll find out that in practice they didn't work very well, so they got overhauled, and then come up with your own jurisdiction's proposed rule.
Yeah, I love that. That's it's wonderful. In Nevada, we have the same thing. It's Supreme Court rules that cover electronic coverage, and I use them all the time. They're fantastic. We also have we have Solid V 8th Judicial District Court, which I've used as a sledgehammer to squash so many objections. Most of the time, the attorneys don't want me in there. The judges seem a little iffy on it. The family division judges do not want cameras on them ever. But the other judges are pretty open to it. And I couldn't agree with you more that I think it helps in so many different ways with public understanding judicial competence and
And
how the
without
system
going
works.
to too much detail, in my experience here is that the response to my YouTube channel, which is Utah Family Law TV, which focuses on domestic relations and family law court proceedings, has been almost uniformly antagonistic and hostile.
Not surprised. It doesn't
Not
surprise
very
me for
welcoming at all.
No.
And lots of denials based on just twisted constructions of the rules. It's been very disappointing. It has eroded my faith in the legal system in many ways irreparably.
It's done the same thing to me.
So folks, if you're looking into to getting electronic coverage and thinking, well, gee, the courts want it's their public courts. They knew this when they took the job. Some states it looks like you may get a warmer reception than others. But don't let that stop. And this is a good thing for everybody.
And if any of you gets a chance, both your viewers and mine, take a look at Judge Judy's Norm MacDonald interview, because she says the exact same thing, that she thinks there should be cameras in these family courtrooms.
I've seen that interview.
It's a wonderful interview. And a lot of people, if you think she's just a TV judge, she has a history. She was a supervising judge on the family court bench in Manhattan for years. So she's not just a TV judge. She knows what she's talking about. So the next question here is from iTumblers. He says, generally speaking, how much immunity does a guardian ad litem have towards legal action towards them? The GAL involved in his or her case withheld a lot of information to the court. And they're just curious.
I don't know the answer to that, although I do know generally a guardian ad litem is given quite a bit of immunity, so that just like with other government jobs, like a police officer or something like that, who has to do some difficult things and has to make some difficult choices. I mean, if every time a police officer harms somebody in the performance of an officer's duties, nobody would have the guts to be a police officer. So as long as what you can say is that, yes, I may have caused some harm or damaged some property, but it was within the line of duty and I was trying to do a good job, then there's immunity for that. And that makes sense. And then, of course, when people abuse that privilege, that's when people start to get angry. With a guardian ad litem, they are shielded from civil liability and even some criminal liability with regard to their job. But if you caught a guardian ad litem lying through his or her teeth, or getting bribed and bought off, or taking it out on you because you are of a different race, or because they have some kind of prejudice against your religion or your politics, that person can be sanctioned at the very least, and could be suspended or disbarred at the very least, as well as facing some civil and criminal sanctions. But it's much more difficult than with a regular attorney.
Here's some comments here of people who agree with you. Shay says that the use of any of those third-party providers is such an extra expense. You have a question here from Karen McNaughton again. She's wondering if parenting coordinators, specifically parenting coordinators, ever meet with the entire family, or if they're just like a mini judge and they really just sort of are a center step in the process of litigation.
There may be, depending upon what jurisdiction you're in, certain rules that may prevent a parent coordinator from doing that. There may be others that require them to do that very thing. But I would say, generally speaking, if, for example, if I were made a parent coordinator, which I would not be because I would say save your money, is if they wanted me to meet with the kids and talk to the kids, I'd say absolutely. It sounds like a great idea. I'd get to know them better. I'd get to know the family dynamics better. If somebody said, I'd like to speak with you personally, one of the parents, I'd say, great, it's going to cost you, you're going to get billed for it, but I'll be happy to do that, and I'll give it my best and listen to what you're saying and try to make sure that I get an accurate portrayal of the circumstances. So in other words, don't be afraid to ask. The worst that can happen is they'll say no, and if it turns out they're supposed to do that and they said no, then that might be grounds for throwing that particular coordinator off the job and either getting nobody to replace him or her, or getting a good coordinator, if you can find such a thing.
Mm-hmm. In my on my video parenting coordinators, I actually recommend just vetoing them without even thinking about it.
You and I are the same. I find them to be. They do not deliver value for the money. They often make things worse.
Right. I love that. I mean, it's crazy how we came to the same conclusions. So here's a comment from somebody who agrees with you, and then I'll follow up with a question from same person. So iTumbler's comment is that his GAL didn't even interview him in the last 5 months of the case, and that the jail already decided what he was going to do because he wasn't represented by an attorney. That's just a comment. The question is, I'm going to reframe this a little one. The basic question is, if the other parent lies in court, can you file a lawsuit against them, or can they be prosecuted for perjury? And I want to reframe that a little bit to sort of open the door of, if that isn't really the best approach, how do you recommend people deal with liars? Because this is extraordinarily common with self-represented parties, and they sometimes get stuck on that, and they won't look at the case completely. They'll just have these blinders on, and they'll focus only on these lies and trying to get that addressed. Go ahead and go all out with that one.
Number one, I like practicing law. I like practicing divorce and family law. I am embarrassed to be an attorney. And so what I mean by that is that there are a lot of divorce and family lawyers who make a mockery of the system and who game the system for their clients. They're kind of prostitutes. They'll say, you want me to get a result, whether you deserve it or not, I'll get it for you by hook or by crook, we'll get it. Okay, I'm not that guy. I don't blame the people watching and listening if they don't believe me. But I just want to assert up front that I know that that's the opinion of a lot of people when it comes to divorce and family lawyers, and it is not undeserved. There are good divorce and family lawyers out there, but there are a lot more that aren't, in my opinion. Now, I do this at risk to myself, but I'm not going to tell you something I don't believe just to protect myself. The profession can get better, and the system can get better, and needs to, because people are not being adequately served. And there's a lot of people in the system that don't want to admit that, and they don't want to have to do the hard work of making things better, so they shut down voices of dissent. But if there are no voices of dissent, then they have one. So I'll say that first. Now, the second thing I'll tell you is that there are different kinds of lies that are told, and let's face it, some are more serious than others. If you get to a hearing and the other person is late and said, "Oh, sorry, I had a flat tire," and it turns out that person just got up late and didn't bother to show up on it. That's not really perjury, because it doesn't really have anything to do with the merits of the case and have an impact on the outcome of the case. So if you were able to prove, "Oh, that person was lying, they didn't have I've got all the security footage for all the cameras on the route from home to courthouse, and I can show you there was never a breakdown, no flat tire." You know what I mean? It's like, well, the court's going to say, I'm not going to hold this person accountable and sanction that person for perjury.
Yeah.
A different matter would be, well, I believe all the claims that you were, I'm trying to think of something where you could prove it. Well, let's just assume that you're accused of being a rapist, a spousal rapist. And it's just like, oh, he rapes everything. Like wife, kids, rape, and and then lurid details about all the terrible ways these rapes were committed, and all, and just picturesque scenes, that just make your stomach turn because they're so detailed and vivid. And it turns out that you've never raped anybody in your life. You were lying, so you lost custody of the kids. You were supervised. You got to barely see them at all. The children were told over and over again that dad's a rapist. He raped mom. He raped you, and all this other kind of stuff. And so now you're alienated from your kids. They want nothing to do with you. And then let's assume that one day you finally think, I've had enough, and you hire a private investigator. The private investigator goes and finds your ex and talks to her at the bar or something like that, and she spills all, like, "Oh yeah, I was a setup for the whole thing. I lied through my teeth. He was a great father, but I'd be damned if I was going to lose custody of my kids, so I just made up lies. I knew I could get away with it because I had some divorced friends who had been through this before, and they kind of told me, what to do, and they showed me the rope." And then if you went back to court and said, "Look, Your Honor, I was framed, I was, ruthlessly lied about," then that's something the court might punish someone for perjury. Might.
I love how you stress might.
I have found that courts rarely seem to be interested in perjury in the family law context.
It's the same here and probably everywhere. I do have one remark for the viewers. This is going to sound like a moment to celebrate, but it's really not. This is actually underlining exactly what Mr. Johnson said. Our Nevada judges did provide electronic coverage of a father who was convicted of perjury and forgery, and I want you to watch if you guys are really interested, watch the trial, and you'll see why the state is so reluctant to actually get involved in these child custody disputes where you have perjury and forgery and all that stuff going on. The amount of work that went into the prosecution, and I can't imagine the resources the state put into it. This should tell you guys not why more judges should do it. It should give you an idea as to why it's so hard to get the state to go and deal with these problems. That case was like, I could only describe it like World War I trench warfare. It was not a quick and easy, here's a 2-hour trial conviction. No, it was a days-long event with a jury, and then there were post-judgment proceedings that went into oblivion, appeals all over the place. So that if you guys watch the state of Nevada versus Michael McDonald, you'll see why so few of these cases are actually prosecuted. Yeah. It'll make sense to you. It's a ridiculous amount of work.
Yeah, in fairness, that is a tremendous drain on judicial resources. There's so much lying that goes on in so many domestic relations cases that it is fair to say that the system would be overwhelmed. And they have to pick the most heinous examples.
Right. In this case, it was a letter from, and I'm okay talking about it because it was already convicted and affirmed on appeal. There was a letter that the father said a mental health expert provided, and he inserted some language into the letter, and that's why they went after him. It seemed like a cut and dry case, but the defense attorney fought tooth and nail like you would not believe. It was anything but an easy case for the state. It was just grueling, and for my staff, I mean, we were just dead from having to run to court. Like it was, I can't even, like, there's trauma for us from having to cover all those proceedings. It was nuts. So guys, go ahead and take a look at the state of Nevada versus Michael McDonald. You'll see why perjury is hardly ever addressed. It's nothing like what you think. It's to prosecute somebody for something like this. It's exactly what he said. We have a bunch of comments here. I'm going to go through them. They're all in agreement with you. One here. Speaking to Mr. Forward, we must review our legal options against corrupt actors in family law. They're messing up people's lives. A comment here from iTumbler says his first lawyer recommended it and that it was the stupidest thing that could have happened to him. We have, let's see here, Shay appreciates you very much for providing a peek behind the curtain on custody evaluators. HC9 says, thank you hugely. In his state, all of the parenting coordinators, counselors, etc. are scared of high conflict exes, and they almost won't talk to you unless they are court ordered to. I'm looking for a question here, but I'm happy to let you know that the viewers are very appreciative of you.
Sure. While you're doing that, I'll just say a little bit about why I think a judge should interview the kids a little bit.
Go ahead.
Too.
Go ahead.
So while you're doing that, and go ahead, folks, let your other questions come to the fore. But it costs anywhere between $3,000 to $10,000, and it can be more depending upon how vicious the fight is. But these custody evaluations are a lot of money, and you already don't have money to pay for everything that you have to pay for, plus hire a lawyer, plus pay for a custody evaluator. But the courts, which is weird because courts can't order people to do things they can't do. You can't be put in, for example, you can't be held in contempt for failing to pay something that you can prove you're unable to pay. So if there's a judgment against you that you're supposed to pay in installments of $500 a month, and then you break your neck, you can't be brought into court and held in contempt, because one of the defenses to that would be, it's like, look, it's not that I'm refusing to pay, it's that I can't. But whenever I've tried to say, look, the parties just don't have the money for this, the court will just say, oh, well, with the stroke of a pen, I have deemed them to have the ability to pay, and they will. And I just thought, well, that's crazy. And then the second thing is that even if you did have the ability to pay, we've talked about how this is second or third hand information in a custody evaluation or a guardian ad litem, is that this is somebody who purports to speak to the children and then tells the court, and it's not the entire interview, and it's just a summary, and this is something that this person is going to claim happened, whether it happened that way or unfolded that way or not. And that summary may leave out some details that the court might have found very useful, but that the guardian ad litem or custody evaluator did not. If you have the judge interview the child, then first of all, it keeps the judge on his or her toes, knowing that that interview is going to be on the record. I mean, that's why everybody supposedly is on their toes, is they know that it's on the record. You can't just tell a whole bunch of lies and think, well, don't worry, it was such a long trial, nobody could possibly remember everything. It's precisely because we can't remember everything that we make a record. And as you know, is that if somebody later on wants to appeal, they can say, all right, I may have had to go back and listen to that week-long trial, but I was able to remember. I seized upon this and this and these irregularities and these sorts of things, and that's the basis of my appeal. If you've got a judge interviewing the child, you get to hear what the judge asks. You get to hear what the child says. So if let me give you another example. If a judge asked a bunch of questions of a child, and they were all basically, no, I want to live with mom. No, I want to live with mom. No, I want to live with mom. Oh, I understand. Dad's not the worst person in the world, but I want to live with mom. Here are my reasons. I want to live with mom. And then the judge comes out and says, well, I've spoken to the child, and I have determined that the custody should be awarded to the father. Well, if you didn't have a record of that, you'd just be going, well, gee, I guess the child wants to live with dad. And then, of course, poor mom, walks out of the courtroom, dabbing at her eyes and drying the tears, and says, I wonder what I did wrong. I really thought that, that it was clear that my husband has been violent toward me and the kids. I thought that would come out. Well, I don't know. I guess maybe he got to the kids and they've lied to the judge, or maybe I'm not as popular with the kids as I thought I was. Well, you can imagine how good that would feel for the person in mom's position, whether that be a mom or a dad, to go back and listen to the record and find out, it's like, oh my gosh, for whatever reason, the judge had it in for me. I should have won all along. Now, that's, by the way, if the child says, I want to live with mom because she lets me drink alcohol and smoke weed, you know what I mean? And I don't want to live with dad because dad makes me do my homework, well, that's different. But if it was clear that the judge was just had it in for mom, thank God that you have that record. Yet and this is interesting, and when I bring that up and I say, well, at least if you're going to appoint a guardian or a evaluator, Your Honor, make the interviews be on the record. They'll ask me, it's like, Mr. Johnson, do you suppose the guardian ad litem or custody evaluator would lie? I was like, well, number one, I don't know if they'd lie or not, but I do know one way to ensure that they don't, and that is make a record of the interview. And secondly, this is interesting, Your Honor, we hold you to a standard that says your interview has to be on the record. So apparently we trust the judge less than we trust the custody evaluator or the guardian ad litem. That just doesn't wash. The fact of the matter is, we need a record so we know what really happened. And like you said, so if there's some irregularity, some violation, we can appeal it and have justice done.
Right. I don't know if you know the extent to which I use the appellate courts, but I won 4 Supreme Court appeals, improper person. And I was also published on a petition for writ of mandamus on a child custody issue with regards to a father's right to know where their child resides. That's published
without knowing your history, that seems to speak well both of you and your court system.
Yeah, the justice that authored the opinion was very detailed. He thoroughly analyzed the way that the confidential address program was abused by the government, and he created this doorway for other parents after me, where they could cite Falcone v. Secretary of State and get that kind of relief from the district courts. There is a slew of comments in support of you. Everybody's very appreciative of you coming on camera. There's so many topics that we can cover in the future, but I'm going to poll my viewers and ask them which one specifically you want to talk about. There is also questions by people who want to go more into the tangent you discussed, where a parent can manipulate the child into telling the judge something that's harmful. But that's not today's topic, and that is a can of worms, so we're going to set that aside. And then here is the question. This question I have a lot to say on as well, but you're going to go first. The question is from HC9. Does Mr. Johnson think the judges need more training before they interview children?
No.
I'll
be happy to explain.
Go ahead and explain. I want to explain after you why I agree with you. Go ahead.
All right. A lot of people seem to confuse training with expertise. And the fact of the matter is that while I won't be able to drive a car if I've never been behind the wheel before, and let's call it a stick shift in this case, I think that if you put 100 people behind the wheel of a car, maybe one of them might naturally figure it out just from the get-go. So there are certain basic skills you have to learn before you can do certain things. So to drive a stick shift, you need to learn how to operate the clutch. But after that, you don't need to become a race car driver to be an effective driver. And while it might be nice in 1 in a million situations where it's like, well, it's a good thing that I had all that Formula One experience that got me out of that accident, most people are going to say, no, I'm a competent driver. I can do what it needs to be done. 9 out of 10 times, nothing more can be expected of me. So judges are, for the most part, among the cream of the crop of the legal minds. Not always. There is a lot of politics in judges being appointed or elected, depending upon how it's done in your jurisdiction. But they tend to be among the best. And so talking to, by the way, I don't know if you were aware of this, but we were all once children at one time in our life. And so every judge knows what it's like to be a child, and every judge, most judges, I would say, have been parents, or at least have a nephew or niece or something like that they've interacted with. And these are people that understand the law, and they know what the factors are that they're supposed to consider, and they should be able to put together some questions that are age appropriate to elicit from the child the facts that they're trying to get, and the feelings and concerns and opinions as well, if that's what they want. So more training, like it happens to be a rather clumsy questioner, and some judges might be. They might be brilliant analytical minds, but bad at asking questions. Well, okay, then maybe give them a seminar or two on how to ask questions, how to ask open-ended questions, not leading, stuff like that. But otherwise, no. It's not a matter of it's not a lack of training, it's a lack of caring.
I strongly agree.
When they're bad at it, it's because they just don't take it seriously.
That's exact. I mean, I have stated the same exact thing because people ask me, what kind of training do judges need? And I'm like, need none. If they love their job, they will on their own find out how this stuff works. They will on their own get training. If we need to tell them that they need to get training, they need to be fired. And my experience over the past 8 or 9 years, not only with our Nevada judges, but also with my work as a self-represented litigant, is that the judges, sadly, for the most part, did the right thing in my case because the Supreme Court said so. They didn't come to the conclusion of we need to do these things because it's logical, it's fair to the child, it's what's best. By the way, my ex's parental rights have been terminated, so my case is completely and totally over. It's closed, cannot be reopened. So none of this is to garner sympathy or support. I'm done. My wife adopted him through a step-parent adoption. My realization was that, unfortunately, what seems to work is firings and orders reversing. It's really sad, but I think that the better way to get better judges is to replace them with judges who care, with judges who want to do the right thing. I don't think that it's a working system. In fact, it would have been working by now to tell judges, you're not doing a good job, go get some training. The only thing that seems to work here in Nevada is to replace them with somebody else. And I'm sad to say that that's not a conclusion that I trumpet. That's not something I think we should celebrate. That's me being candid with my viewers. This is something that I've said for throughout the channel. Go ahead if you want to.
I'd be lying if I said there were times that I didn't entertain, like, gee, I think it'd be nice to be a commissioner or a judge myself. But the older I get and the more interactions I have with judges, especially the retired ones who will, be more candid because their job's not on the line. It's a thankless job. It's an extraordinarily difficult job. I had one judge where I said, what was the hardest part of being a judge? And he said, sentencing people to life in prison. And I just thought, oh yeah, I wouldn't want to be, how about this? Sentencing someone to life in prison who was innocent. But I didn't know, you know what I mean? I did my best. I'm not sure I would sleep really well. No, I mean, once I found out that I sent an innocent man or woman to prison for life, that'd be a hard thing to live with. So I have sympathy for judges and the difficult job they have. What I don't have sympathy for is when they say, well, because my job is so hard, I can be lax in certain areas of the job. No, you've got to do all areas of the job as best as you possibly can, or you need to find another job.
I completely agree. I was going to wrap it up, but your remark about the sentencing wrongful conviction, actually, I have to talk about that a tiny bit. In the recent election in Nevada, we have what I call a tale of two judges, where two judges were involved in the conviction of an innocent man. The Supreme Court issued an order stating that he was convicted wrongfully, and the two judges reacted completely differently. One of the judges cried, testified in front of the legislature that he wanted statutes created to compensate these victims of the legal system of miscarriages of justice. The other judge dug his heels in and said that he believed that the person was guilty and he didn't care what the Supreme Court said, stuff like that. And the outcome in the election was interesting. The judge who dug his heels in has lost his seat. The electorate voted him out. The other judge, who apologized and wanted to make the system better, has been elected to the Supreme Court of Nevada, and he is now a justice. If you care to, you can remark on that if you want to. I just wanted to tell my viewers and you. If you'd not like to, we can go ahead and wrap this up. It's up to you.
I will wrap it up with one thing, and it's something that I don't think some people may have noticed, and that is, so we've talked about how guardians ad litem and custody evaluators really don't justify the expense. They don't add the value that they may believe to be adding when you hear about the concept. But a judge interviewing a child costs you nothing.
Mm-hmm.
And it's from the child's mouth directly to the judge's ear,
Mm-hmm.
and it's on the record.
Mm-hmm.
So it's inexpensive. It's not just inexpensive, it's free of charge. It's on the record, so there's no chance of anybody misconstruing what was asked and what the child said. And third, it's not parsed through somebody else, summarized and diced and chopped and represented as something that it may or may not actually be. And because of that, I can't see any reason why anyone would say, for the rank and file custody cases, why anyone would want to do it any differently than that.
Mm-hmm. Thank you so.
Ask for it. Ask for it when you're in there. Don't think that you're stuck with having to pay all this money to all these experts when you can say, look, Your Honor, I don't see why the child speaking directly to you isn't vastly superior to all this other stuff.
Yeah, in fact, maybe.
Be prepared for lame excuses. But at least make the arguments, and you can listen to what we've said here. And I've got a series that I've done on UFL TV that goes into more detail. But it's time that we stood up to this, because I have now concluded for myself that it's just not. It's funny that it's the last thing that we ask, the last thing that the courts are willing to do, and it should be the first thing that they volunteer to do whenever there's a question in the court's mind that could be solved by interviewing the child for it.
Yeah, I very strongly agree. It's time for us to stand up to it. I encourage all of you to please go to Mr. Johnson's channel, Utah Family Law TV. Please subscribe to that channel. Take a look at his videos. He has all kinds of stuff that I think would be extremely helpful, not just to residents of Utah, but to anyone else that's going through one of these child custody cases. I appreciate you very much, Mr. Johnson. Thank you, and hopefully we'll see you again in the future.